So welcome back, dear students. Today we are going to learn the drafting of a notice under section 106 of Transfer of Property Act. This notice is a notice terminating the lease or tenancy of a tenant before filing a suit for ejectment. Dear students, you must know what is a lease before you send a notice terminating the lease. According to section 105 of TP Act, a lease of immovable property is a transfer of a right to enjoy such property in consideration of a price paid or promised, or of money in the shape of rent, or a share of crop as rent, or services as rent, or any other thing of value to be rendered periodically. This rent or rent in cash or kind may be paid monthly, quarterly, 6 monthly, or even annually, or on specified occasions, say Diwali to Diwali, the rent is payable to the transferor or the lessor by the transferee, that is a tenant or lessee, who accepts the transfer on certain terms and conditions. Dear students, in this transaction of lease, transferor is known as the lessor and transferee is called lessee, and the price which is paid over and above the rent is known as premium. Premium is also known as, in common parlance in Hindi language, this premium is known as pagdi. Suppose you are going to take a shop on rent in some mall situated at Sector 18 in Noida. Then besides rent, you will have to pay premium in advance. And this premium is quite high, say 2 crores or 3 crore rupees, which is not non-refundable. And then you are supposed to pay monthly rent also. Monthly rent may be 1 lakh rupees per month or so, but premium is always in crores for commercial establishments. Now, dear students, we are here to learn today the drafting of a notice terminating the tenancy of the tenant. The previous law was that in residential buildings, you are supposed to give 15 days notice, and in case of lease for agriculture or manufacturer purposes, the 6 months notice was to be given, and this notice of 6 months or 15 days was to expire with the ending of the year of the tenancy or expiring with the ending of the month of the tenancy. But now, dear students, TP Act has been amended by Transfer of Property Amendment Act 2003, and with effect from 1st March 2003, a new section has been substituted in the TP Act, and now notice expiring with the end of the year of a tenancy and notice expiring with the end of month of the tenancy is not a legal requirement. This portion shown in the red in this slide has been removed from section 106 by TP Amendment Act of 2003. Dear students, section 106 enumerates certain cases. It gives you duration of lease in certain cases. And in the absence of a contract or local law or usage to the contrary, the normal law is a lease of immovable property for agriculture or manufacturing purposes shall be deemed to be a lease from year to year, terminable on the part of either lessor or lessee by 6 months notice. And previous law was that this 6 month period should expire with the end of the year of a tenancy, which is not the law today. And B, A lease of immovable property for any other purpose, that means residential purpose, shall be deemed to be a lease from month to month, terminable on the part of either lessor or lessee by 15 days notice. And this period of 6 months or 15 days shall be counted from the date of receipt of the notice. When notice is received, thereafter, the tenant of a residential building remains a tenant for 15 days more so that he may search another house. And likewise, the tenancy for agriculture or manufacturing purposes also continues for 6 months more after termination of tenancy so that business may be wind up and the sown crop may grow and the tenant may cut the crop for his benefit. Dear students, there is a misconception in legal circles that notice to quit or notice terminating the tenancy of a tenant can be given by landlord only. But the legal position is the other way around. A notice under section 106 can be given either by the lessor, that is the landlord, or by the lessee, that is the tenant. Both have equal right to terminate the tenancy. So, the law is that a notice under section 106 of TP Act, it may be a 6 months notice in case of agriculture property or property rented out for commercial purposes, or it may be 15 days notice in case of residential buildings. This notice must be in writing and signed by or on behalf of the person giving it. There cannot be oral termination of tenancy. And this notice must be sent by post or tendered or delivered personally to the party or to one of his family members or servants at his residence, or if such tender or delivery is not possible, then by affixing the notice at some conspicuous part of the property. So these are the ways of communication of the notice. Now, dear students, this amendment which I told you has taken place in TP Act. It has retrospective operation. New section 106 will apply to all notices in pursuance of which any suit or proceeding is pending at the commencement of this amending act, and B, to all notices which have been issued before commencement of this amending act where no such suit or proceeding has been filed before such commencement. So both ways this operation of amendment is retrospective in operation. Now, dear students, how do you calculate the term of the lease before you are going to terminate the tenancy of your tenant? Whenever you calculate the term of the lease, exclusion of the day on which the term of lease commences, you will exclude the first day of commencement of the lease. A, where the time limited by lease of an immovable property is expressed as commencing from a particular day. So in computing the total period, such day shall be excluded. For example, if lease is to begin from 1st January 2020, this first day of January shall be excluded while calculating the total period of lease. This is the mandate of section 110 of TP Act. And B, where no day of commencement is named, the time so limited begins from the making of the lease. This is also mandate of section 110 of TP Act. Now let us take an example how to calculate the term of a lease for a year, where the time so limited is a year or number of years. Then in the absence of an express agreement to the contrary, the lease shall last during the whole anniversary from the day from which such time commences. For example, if it was a lease for 1 year with effect from 1st January 2020, then this lease will commence from 2nd January, not from 1st January. 1st January has to be excluded. So the lease will commence from 2nd February 2020 and it will continue up to 1st January 2021, whole of the anniversary, whole of the 1 year. So lease is to be calculated from 2nd January 2020 and it will go up to 1st January 2021. Now you are going to determine the lease. You are here to draft a notice for determination of lease of the tenant. So dear students, whenever a notice of termination of lease is given, the period of 6 months or 15 days as the case may be, shall be counted from the date of receipt of the notice. Because it is the receipt of the notice by which tenant will come to know that his tenancy has been terminated. So this period of 6 months or 15 days shall be counted from the date of the receipt of the notice and lease will remain valid until expiration of the notice. And lease will be determined on the expiration of notice period to determine the lease or quit or intention to quit the property leased. And after service of notice, the tenant remains a valid tenant for further 15 days in case of residential building, and he remains a valid tenant for 6 months more even after termination of tenancy as the case may be. Now let us take another example, how to determine a month-to-month lease. Why this is important? Because you are going to draft a notice terminating the lease of your tenant. Suppose the lease was for 11 months only on month-to-month basis and it started from 1st January 2020. So 11 months will expire on 30th November 2020. Now in between, suppose a notice dated 1st April 2020 was given by the lessor to the lessee, terminating the tenancy. And this notice dated 1st April was received by the lessee on 5th April 2020. So dear students, the period of 15 days will be counted from 5th April 2020 and the lessee will remain a valid lessee up to 19th April 2020. So this period from 5th April to 19th April is available to the tenant so that he may search for another accommodation. And it is not necessary now, as I told you earlier, that monthly lease should terminate with the date of ending of the month. Now let us take an example of determination of yearly lease. Suppose a yearly lease was given for agriculture or manufacturing purposes for 10 years on 1st January 2010. So first day is to be excluded. The period of lease will start with effect from 2nd January 2010. And normally this period should end on 1st January 2020 after 10 years. Now in between, a notice of termination of lease is given by the lessee to the lessor. See here, lessee is terminating the lease. Yes, he has a right like that of a lessor. So notice of termination of lease is given by the lessee to the lessor on 1st January 2019. And the notice is received by the lessor on 7th January 2019. So this lease will continue up to 7th January 2019 when the notice of termination was received, plus 6 months more. And lessee remains a valid tenant up to 6th June 2019. So he has 6 months period to wind up his business or to wind up his grown crops, etc. Now, dear students, we will start with this exercise of drafting of notice under section 106 of TP Act for determination of lease given on monthly basis by a landlord to his tenant. Now we dwell upon the actual drafting portion. Heading will be Notice to Tenant under Section 106 TP Act 1882. And dear students, since this notice has been drafted by some advocate of the landlord, so this notice will emanate from the office of ABC Advocate. You will write down his complete address, chamber number 106, High Court of Delhi, Sher Shah Road, New Delhi. Why I have mentioned this chamber number as 106? I am highlighting it so that you may be reminded that this notice is being drafted under section 106 of TP Act. Likewise, after the complete address of the sender, you will write down date of notice. Date is 1st January 2017 and mode of sending this notice is by registered AD and UPC. UPC is under postal certificate. Now to whom you are addressing this notice? You are addressing this notice to the tenant, to A son of B, the resident of 106 Lajpat Nagar, New Delhi. Here 106 I have again highlighted so that you may be reminded that this notice is being drafted under the provisions of 106 TP Act. Now the opening line of this notice will be drafted like this. I have instructions from my client, Shri X son of Y, resident of 52 Lajpat Nagar, New Delhi, to serve you the following notice. Para 1. That my client is the owner and landlord of property number 52 Lajpat Nagar, New Delhi. Para 2. That you are a tenant of my client in respect of one room, a kitchen, a bathroom, and a store on the first floor of said property at a monthly rent of rupees 10,000 per month only, besides water and electricity charges, void rent agreement dated 1st July 1988. Para 3. That the above said tenancy commences on the first day of every English calendar month and expires on the last day of the same English calendar month. The rent is payable in advance on the first of every English calendar month. Para 4. That the above said premises under your tenancy are residential in nature, were let out to you for residential purposes only, and it is also being used by you for residential purposes. Now, the reason of termination of tenancy is given in para 5. Although no reason is required legally, you can terminate the tenancy of your tenant without any cause also. Para 5. That you are a regular defaulter in paying rent to my client, and now the rent for 30 months with effect from 1st July 88 to 31st December 1990 has become due from you. I therefore hereby call upon you to pay the whole of the arrears of rent to my client within 2 months of this notice. So this is your demand for arrear of rent. Para 6. That you have acquired vacant possession of flat number 106 Rohini, New Delhi, and have therefore made yourself liable for eviction on this ground also. Here also, the property which tenant has acquired, I have mentioned its address as 106 Rohini. Again, to remind you that you are drafting a notice under section 106 of TP Act. Para 7. This is the main para. That my client does not wish to keep you as tenant anymore. No reasons are required. Your tenancy is therefore terminated with effect from midnight of 31st January 2017 after having availed 15 clear days from the date of service of this notice. Para 8. You are therefore hereby called upon to pay arrears of rent and hand over the vacant and peaceful possession of the said premises to my client upon termination of your tenancy. Last paragraph. Please take notice and be notified that if you will not vacate the said premises on or before 31st January 2017 and will not pay entire arrears of rent, I have instructions to file a suit for arrears of rent and ejectment against you at your risk, cost, and responsibility. Copy of the notice is retained by me. Date of the notice is 1st January 2017, and this notice is being sent by ABC Advocate, who will gently address you as yours faithfully and will put his signatures before his name, ABC Advocate. Dear students, please note whether the legal requirement of termination of tenancy of a tenant has been complied with or not in your drafting, because your drafting has to be legally correct. So see, in this notice, a period of more than statutory period of 15 days is given. How? Notice was given on 1st January 2017. You add period of service of notice, say maximum 7 days, plus 15 days he remains valid tenant. So this tenancy will be terminated somewhere in the 3rd week of January. 1 week for service and 15 days for valid tenancy continuing even after the termination. So here the tenancy should terminate somewhere in the 3rd week, but you have terminated the tenancy with effect from 31st January 2017. Hence, the statutory requirement of minimum 15 days notice after service of notice to quit is complied herewith. So your drafting is, in a sense, correct. Now, dear students, this was an example where month-to-month tenancy of a tenant was terminated. Now let's take another example where we are going to draft a notice. Of course, again under section 106 of TP Act, but here we are terminating the tenancy of a lease of land given for agriculture purposes. So you will have to give 6 months notice. So heading will be as such: notice to lessee under section 106 of TP Act 1882. Since this notice has been drafted by advocate of landlord, so this notice has to emanate from the office of that advocate. So you will write down and you will draft it like this: from the office of ABC Advocate, chamber number 106, High Court of Delhi, Sher Shah Road, New Delhi. Dated, date of notice is 1st January 2020. And mode of sending is by registered daily post and under postal certificate, that is UPC. Now, to whom you are addressing this notice? You are addressing this notice to the tenant. And tenant is A son of B, resident of 106 Lajpat Nagar, New Delhi. Opening line will be the same as it was in the previous drafting of notice. I have instructions from my client, Shri X son of Y, resident of 52 Lajpat Nagar, New Delhi, to serve you the following quit notice. Para 1, that my client is the owner and landlord of agriculture land property number 52, measuring 5 acres, situated at Chhatarpur, New Delhi. Para 2, that you are a lessee or tenant of my client in respect of the said agriculture land at a rent of rupees 10,000 per month only per acre, Void rent agreement dated 1/1/2010. Para 3. That the above said tenancy commences on the first day of every English year and expires on the last day of the same English year. The rent is payable in advance on the first day of every English calendar. Para 4. That the above said land under your tenancy is agriculture in nature and was let out to you for agriculture purposes only. Now, dear students, you will have to give a 6 months notice for termination of tenancy. Why? Because the land was given on lease or rent for agriculture purposes only. And again, no reason is required for terminating the tenancy, but here the landlord has a valid reason also in para 5. That is, you are a regular defaulter in paying rent to my client, and now the rent for the 5 years with effect from 1/1/2015 to 31st December 2019 has become due from you. I therefore hereby call upon you to pay the whole of the arrears of rent to my client within 2 months of this notice. This is a claim for arrear of rent. But now we are to terminate his tenancy. And that is the mandate in para 6 from the side of the landlord. Para 6, that my client does not wish to keep you as tenant anymore. No reason is required. Your tenancy is therefore terminated with effect from midnight of 31st July 2020 after having availed a period of 6 months from the service of this notice. Para 7, you are therefore hereby called upon to pay arrears of rent and hand over the vacant and peaceful possession of the said agricultural land to my client upon termination of your tenancy. And this is the final call. Please take notice and be notified that if you will not vacate the said premises on or before 31st July 2020 and will not pay entire arrears of rent, I have instructions to file a suit for arrears of rent and ejectment against you at your risk, cost, and responsibility. This is the final direction, final line of action which the counsel for the landlord has given to the tenant. And lastly, you will have to mention that copy of the notice is retained by me. Date of notice is 1st January 2020, and ABC Advocate is addressing you as yours faithfully, ABC Advocate, and he will put his signatures also on this notice. So, dear students, let us see whether the requirement of law has been complied with in the notice drafted by you or not. So, let us take a test. And the test is that in this notice, a period of more than statutory requirement of 6 months is given. How? See, notice was sent on 1st January 2020. Period of service, you may add 7 days maximum. Plus 6 months more, he remains a valid tenant. So the tenancy is likely to be terminated in the 1st or 2nd week of July 2020. But here in this notice, you have terminated the tenancy with effect from 31st July. You have given more time to the tenant. So statutory requirement of minimum 6 months notice after service of notice to quit is complied with. So dear students, this is how today we have learned the drafting of notice to quit on behalf of the landlord to the tenant for residential purposes as well as for agriculture or manufacturing purposes both. So thank you very much.